Friends, in this episode, we're going to talk about what the heck's going on with the public charge rule. There's been a lot of back and forth, as you can understand, with lawsuits really across the country. You'll want to watch all the way to the end so you understand what is going on with the public charge rule. Friends, welcome to Green Card Guys TV. I'm your host, John Ting. I practice immigration law in all 50 states of America and across the world, where we help immigrants live and work in America legally. To give you some context of just the past month, early November, the Seventh Circuit granted an administrative stay on Northern District of Illinois. So to give you an idea, in Northern District, Illinois, anytime lawyers refer to Northern District, Southern District, Eastern and Western District, that's the trial level of the federal level. And then the Sixth Circuit or Seventh Circuit, Fifth Circuit, where I'm at in Houston, Texas, those are one level above the appellate courts. So after the Northern District of Illinois, the next level was the Seventh District Court, which put a stay to the lower levels order, which the lower level order was to vacate the public charge rule. However, so it's really going back. It's like a battle back and forth. So then the White House, the Trump administration, filed a request for a stay, and the Seventh Circuit granted it. Okay, so now that means the public charge rule is back on, that we have to file the form I-944 along with evidence to show that you're not a public charge per their definition. Now, this is what happened early December 2nd, 2020. The Ninth Circuit, which covers California and Oregon, for example, and Washington State, the Ninth Circuit Court issued preliminary injunctions against the Department of Homeland Security's public charge rule. So that's a good thing for immigrants. However, they vacated the lower courts, the trial level, the Northern District of California, and the Eastern District of Washington State. They vacated that previous order. Specific to Washington State, that order, it granted an injunction that vacated the public charge rule across the nation. Now, what the Ninth Circuit did effectively by doing that was saying, okay, this preliminary injunction is not going to be nationwide. It's going to be respective to the states within the Ninth Circuit. Now, to give you some background about the public charge rule, it's been in place by Congress since 1882, but it's never been defined until 1996, where the Congress added about 5 factors to determine if someone was going to be a public charge or not. And that included family status, age, assets, resources, financial status, education, and skills. And that 1996 law also required sponsors, petitioners to sign an affidavit of support form, which is now known as the 864 form. Nearly the same time, Congress made some changes to the public benefits programs, where it amended the program to where legal residents were not eligible for it until they had resident status for 5 years. By doing that, Congress did not intend for these short-term public benefits to be considered under the public charge and admissibility rule, because it still allowed the opportunity for residents to be eligible for it. And it did not allow any immigrants without status to be eligible for it at all. So I think there's a public misconception that immigrants who do not have status are eligible for short-term public benefits. And that's not the case. Evidence of that includes non-cash benefits, because a broad public policy was to improve general health and nutrition, promoting education, and assisting poor working families in the process of becoming self-sufficient. So that's known that it's supposed to be short-term, not long-term dependency, unlike, for example, Social Security income or temporary assistance for needy families. So all of this was created by what was formerly Immigration Naturalization Service, INS, which is basically now Department of Homeland Security. But back then, INS in 1996 had created guidance to say just that. So this new public charge rule under the President Trump administration essentially reverses that policy. And so that's why there's been several lawsuits across the country, because many families were already on this short-term benefits, which is not intended to indicate that someone is a public charge. And the 1996 guidance by INS actually encouraged people to apply and obtain these public benefits, the short-term benefits, because it can improve their standard of living, to promote general health and welfare. To boil it all down, so right now, if you're in the state of California, Washington State, Hawaii, Oregon, so if you live in those states, you do not have to apply or file the form I-944. Of course, this is very new. This is recent situation ordered by the court, Ninth Circuit. So who knows, maybe next week it could be something different. So stay tuned. It really just depends when you apply. So the sooner you apply now for your adjustment of status, then if you do that pretty much this week, by the time you listen to this video, something new could have happened by the court, because I fully expect the Department of Homeland Security to request a stay of this ruling, meaning that this recent ruling should not take place. However, in the meantime, if you live in a different state, not within the Ninth Circuit, then you still have to apply for the... Now, at the time of this recording, if you live in a state outside of the Ninth Circuit and outside of the other states that have a similar ruling, a preliminary injunction against the public charge rule, then you still have to apply for the public charge form, I-944, and provide evidence to support that. If you know someone else applying for this, if you know someone else going through the immigration process, whether visiting abroad, going through consular process, meaning having an interview in their birth country, or applying for adjustment of status while living in America, please share this video with them. I believe they'll find this helpful. We have information down below of which states that you likely do not have to apply the 944 form, as there's other lawsuits across the country. And you might wonder why I think the White House, Department of Homeland Security, will file a stay of this recent ruling. And that's because they've done it for every single previous case. So stay tuned. That's why the sooner you help your attorney, if you have one, or if you're applying your own, the sooner you file in this situation, the better for you. Friends, if you're new to this channel, please click subscribe down below. Click the bell so you get all the future notifications of our videos, and smash the like button. And please leave a comment. Let us know if you had concern about the public charge rule. If you have any questions, leave it down below. We'll get back to you as soon as we can. Please share this video with your friends, share the news, and let us know how we can help. Friends, if you haven't joined our Facebook group, click the link below. It's called Immigrant Guide and Support Living in America. It's a community where people can share their tips and challenges and what they've experienced, and also tips about how to live in America, essentially, how to get around. Because there's a lot that people need to get acclimated to as an immigrant. Until next time, please continue wearing your mask.